So, warm greetings to all the viewers and welcome to another interesting discussion on the intersection of technology and law. Today we have with us Mr. Sahil Ahmad. Very warm welcome, sir. And thank you for taking time out from your busy work schedule. So, before starting with the session, I'd like to introduce Sir to our audience. Uh, Sir has completed his undergraduate studies in law from Jamia and followed a master's degree in commercial law from Nalsar. And he further strengthened his academic foundation by undertaking a specialized course at the University of Chicago on the intersection of law and technology. Well, beginning his career as an associate at Tech is now currently with 7 years of experience working with ResMed. So a very warm welcome, sir.
Thank you, Bakhtiar. Thank you for having me here.
So, to set the stage for today's discussion, as we all are aware that the government has, after long-awaited has finally notified DPDP rules, and now the whole framework has been said to be implemented in 3 phases. So, sir, I'd like to first of all know what is your preliminary take on DPDP rules.
So, first of all, really happy to finally have the rules with us. So, because it for the last 7 years almost since when the Supreme Court in the Puttaswamy judgment declared privacy to be fundamental right. Since then, I have been keeping tabs on what kind of laws will we have. So, and working with Shri Krishna committee, going into their consultations from that time. So this is 2018, and interestingly, at that time when the committee published their draft rules, draft act and rules, they also accompanied that with a comprehensive report of the reasons behind what the law that they proposed. So that was pretty comprehensive, and in fact, that was the period which gave me a lot of insight into and helped me understand the privacy domain. So since then, we have been waiting, and it's long overdue. So really feeling happy about this. Although I do personally, and many people I know do personally have some reservations on the kind of act as well as rules that we have finally been able to pass through the parliament, and now this regulation that has been published. So my initial take is I'm happy to have it, at least something, rather than nothing, right? So that's the initial reaction, and would love to tell my clients, my business, that finally we have something now. Because earlier when I used to talk to them, they were like, okay, the law is still not in force. Why are you talking to us? So yeah. So now I can say now we have this law in practice, in force. I mean, not in force, but will eventually be in force in 18 months. So it gives a lot of confidence to me as in my job, and as well as to all the privacy professionals in India. So to know when they're talking to business, they're more confident in the fact that it's now already live, and there is a staggered timeline to it. So yeah, I'm feeling happy about it.
So, sir, my next question will be on consent manager. Basically, because DPDP is the very first of its kind that introduces a consent manager as a separate legal entity. What are basically consent managers, and do you think that this is a welcome step?
So yes, I mean, I have my reservations on consent managers. But first of all, I'll give you a brief anecdote on my personal, when did I first hear about consent managers? And it was in the report which Sri Krishna committee gave. And when they were discussing about this, they were talking about the entire idea was that, I mean, we have, across the globe, we had various legal bases, and consent was seen as something which people were not using quite often, because there was a lot of challenges in terms of how consent is the how consent would be actually valid. So it had a very higher threshold, because when the internet age started, and a lot of goods and services were being offered online, uh, there were consent forms which people used to fill in, but there was a kind of consent fatigue in terms of the fact that if you are going to use Yahoo Messenger at that point of time, if you are going to use Google, if they do take your consent, I mean, eventually you give your consent, you can't do anything about it, right?
Oh.
So, and there were quite kind of cases discussed in the committee when I was there, which was like, there was this company in the UK which actually put in their clauses that, you know, if you consent to, you know, sharing your personal data here, and if you consent to using our services, you would, you know, sell your soul to us. But then people consented to that, you know, okay, and move forward. So there was a kind of a discussion that was happening that, okay, consent might not be a good idea. But they, and so there are two different directions that that actually took place, and one was the GDPR way, and one was the DPDP way that we took. So to overcome this problem, the GDPR decided to not use consent as a primary legal basis. So they said that let's put the obligation on the controllers, on the companies, so that they do the right processing. They don't have those, you know, selling your soul clauses, right? So they have those principles. If they follow those principles, then there's no actual need for consent. So they decided to take off the burden from the consumers, from the users, from data principals, data subjects, to the companies, right? And put all the obligation on them. So that was their idea for this challenge that we saw in the online world. Now, India took a sort of very different turn. India said, okay, we want to use consent, but let's make that consent, you know, some unique initiative where we see that there's a challenge, but let us stagger the consent. Let us ask, you know, companies to have very specific consent for each of the purposes, and they should give, specific. They should ask specific consent for specific processing, all of those things. Can we do that? So there was this, you know, India being, there was a talk of India being, you know, IT hub developing solutions. Why don't we, you know, develop a solution for our users, for Indian consumers who can give and take consent? So it was just discussed in theory, and it was never tested in practice, right? So, and so this is how it, you know, was started. The discussion started and eventually found its place in the law, DPDP, and they kind of the people who were behind it, the lawmakers, backed up this idea and said, no, it is possible. But what they have done in the act is that they've made it optional, of course. So, but I can tell you at that point also there was a lot of challenge to it. They were saying that, you know, you're putting back the burden, unlike the GDPR, on the individuals, to them to take consent and withdraw consent. And considering that, you know, in India, we have a huge population which are not that tech savvy. And I mean, in 2025, and that this discussion was happening in 2018, 19. So this was those circumstances under which we had this. So it was kind of I would say they took a leap of faith. They do think that this might work. And they just want someone to build the technology for them. They're just, in my sense, they're just praying that this works. And if it works, so we'll say, why did they take that gamble? Because during the consultation, there was one thing that I noticed. They were very adamant to not follow the GDPR route. So it was in their back burner that they have to do something different. So that's why I think consent managers was pitched as an idea and was taken up, because then we would say that India is the leader in this, and if we are able to be successful in this. So I think that's the main motivation for having this.
All right. So as to the clout of why the concept of consent managers, so there is still there has not been clear distinction whether will consent managers be considered independent data fiduciaries or will they be considered as data processors. So
So
yeah,
okay, I did hear this conversation happening,
yeah,
and the reason being that I did read about this, but I'm not sure that um, I would not take give an expert advice on this,
yeah,
because I'm not involved that much there. Because for me, I would, and for my business, I would never advise them to have consent managers or hire consent managers,
yeah,
because there are different questions. Because in my understanding, I'm not able to understand that who will adopt consent managers, because the law makes it optional.
mm,
The law basically just says that, and it is not one of the obligations, and neither it is one of the rights of the data principles.
yeah, yeah,
It
true.
says that for consent, data principal may the use of the word is may give their or withdraw or take back their consent through a consent manager, and
Yeah,
that's the only reference that we have in terms of certain obligations, certain things getting created under the law. So, and that provision does not raise much confidence in me that it is obligation either on the fiduciaries, or why would a data principal want to give it through a consent manager? Do they know consent managers?
yeah,
I'm not sure. And so there's real question on what is the incentive for either the data fiduciary or either the data principal. There's a lot of integration that needs to happen, and there are other things that should come in all together.
yeah,
So I think that's why it is difficult for me to fathom that this consent manager would be taken up by either the data fiduciary or the data principal, because I understand that some data fiduciaries might pay these consent managers. So, what's the revenue model for consent managers? They would get paid by data fiduciaries, right? So, if they get paid by data fiduciaries, is there then the conflict of interest? Because consent managers, in consent manager provisions, they say that they should not have conflict of interest
yeah,
with data fiduciaries, right? So there is that, and I think it's not my expert advice, to be honest, learned advice, but I think if anyhow they are supposed to be there, they should be considered as data fiduciaries only, not processors.
all right. So we have seen that you have been very vocal about the problems with reliance on consent. As you have just even talked that India has adopted consent as the mechanism. So, what are these problems, and do consent managers remedy the consent fatigue?
Uh, no, no, not at all. I think the GDPR way is the best way that we can go about this.
Yeah,
Putting the burden on the
data.
I mean the fiduciaries,
Yeah,
and not on the data principles, because we've already seen the consent fatigue. The whole concept is about the principal is not interested, or maybe their interest to use the service is more than their maybe some interest, or maybe they're not aware of their privacy rights, right? So their interest is more towards using the service than to protect their personal data, or how much control they want to have on their personal data. So that's the reason I think consent fatigue would exist. And I mean, it doesn't solve consent fatigue, because people today don't want to have to take that exercise. Only some aware people would kind of go ahead and withdraw, or give consent through a consent manager. And it's still about they don't want to do that. Why would they? I mean, because what happens is, let's take for example, theoretically, that
Yeah.
all the data principals are very aware and they do want to exercise their right. Just consider that for a moment. But in a sense that, the data principle, why would, uh, if they have to give any service, because if you see the definition of consent, they say that if somebody withdraws the consent, the data fiduciaries have a right to not give them that service, right?
Yeah.
So then still that, the compulsion to give that consent to have that service already
Yeah.
exists, right?
Yeah. True.
So they anyways have to do it.
Hmm.
But today, because of this, what happens is they can say they want your consent for you to use certain service because it is necessary,
Yeah.
right? And if they claim so, then you have to give your consent. Then still we come square back to the idea of, again, to the idea that, there is imbalance of relationship and there is consent.
Yeah.
And rather than focusing on the principles that we had in GDPR, where companies have to follow these ethical principles developed over the period of time in Europe and Americas for the last 20, 30 years.
Yeah.
And it kept on refining. The existing version that we see in the GDPR is not, a work of 5 to 10 years. They have had that experience. That's why they brought that law with that thinking, because they already know the loopholes from the
Yeah.
previous legislations, right? So yes, so I think it will not solve, to answer your question, not solve the consent fatigue, and rather could be detrimental to data principals, because they have to anyway give their consent to utilize a service, and the company would say, if you don't, then it's okay. Uh, what good be would be a consent manager, or let's just not say consent managers, even for other cases where somebody is using companies using their own consent management system. In that case, what good it is if you have to give consent to use a service, right?
Yeah. Yeah.
So it's
So,
more important that the principles are followed by the company. They have the retention policy. They do, purpose limitation, all of those things.
sir, so you suggest that GDPR, the form of mechanism that they're using right now, is it appropriate as an alternative to what DPDP proposes, or is there something
Yes,
unique
absolutely.
that would you would suggest besides that?
No, nothing unique to suggest, to be honest, because that's the path that the DPDPA took. Um, so the reason is, you don't start with trying to reach a position A, right? So what felt, I mean, what was wrong with DPDPA being consent centric is that they wanted to it to be consent centric, or wanted it to be different from GDPR, and they wanted to reach that goal, right?
Yeah.
So our goal should be to, have the best regulation. That should be the goal,
Yeah.
right? It should not be that, can we have something different? Can, if they have X, can we have Y? I mean, it's about, maybe if we have some learnings from the GDPR and there are some flaws in the GDPR, which we can learn from and incorporate. And there are n number of things that we can do. But I think as far as legal basis is concerned, they have pretty much captured all the legal bases that, is suitable in the kind of digital landscape, global digital landscape that we have. So it pretty much covers everything. But of course, there's always scope for improvement. There could be something. Maybe I don't have that idea. I welcome some ideas if there is an alternative. But consent, being consent centric and having a consent manager, I do not see it as a solution, as a better solution than the GDPR. So I think the existing one at GDPR, as far as legal bases are concerned, is kind of okay, is perfect, and those are the legal bases that we should use across the globe. That's why, you see, if you check across the globe, we have a similar set of legal bases, not just consent, that we have in DPDP.
So, sir, we are at the end of our podcast. With the last question I would like to ask you, this is a question we ask all our guests, that what inspired you to pursue technology law, like from your law school itself?
Okay, so law school, I was not aware about privacy and data protection.
Yeah.
So not privileged like you guys. So
Good.
so never heard. So I graduated in 2014, and during that time, I think there was a bit of still a lot of scope for IP, so trademark copyright. A lot of fancy people were doing that,
Yeah.
and then there was arbitration, which was coming new at that point of time. So there was people required in that area. So it's only in 2000, after 2021 that it picked up pace in India.
Yeah.
And only after 2023 it became really popular in India, especially among lawyers
Yeah.
and security professionals, that this is something that a domain could be, we could look at this domain. So it was when I was in Nalsar, I did one credit course in privacy. So which is when I was in Nalsar 2018. So that's when GDPR also came in. So there was this one credit course on privacy law, which I took. So someone from Oxford University, a scholar from Oxford, was taking that course, and it was a 1 week course, 16 hours. So I took that course, and that's when I was introduced to the privacy and what's GDPR and all of those things. So since taking that class, I decided that this is something that I wanted to do, and because this is already there in the Europe and in the US as well, other Western countries. So it would eventually trickle down in India, because at that point in time there was no data protection laws, although Supreme Court had declared privacy to be a fundamental right, and Shri Krishna committee was working on this report. So we thought, so we were, I mean, we were very, I think we were the first people in India who got to see that, okay, this is something that we can, build our careers on.
Yeah. Now given the stakes that are involved in DPDP now, yeah, almost everyone will get interested in this. The penalties.
Yes, I think
Yeah.
yes. And of course, I mean, the thing is, it's also people are required in this particular area.
Yeah.
Almost 25 to 30,000 vacancies will be coming in for the next 5 years.
Thank
So
you.
there's a lot of scope. So
Yeah.
there's a lot of scope for, yeah.
Yeah. Continue, sir. Continue.
No, I'm saying there's a lot of scope. That's what I'm saying. So for the next, there's a lot of jobs which will coming in. We need people from various areas. So it's not just lawyers that would be able to, make a name for themselves, create their expertise in this area. It welcomes people from all the, education backgrounds.
Thank you, Sahil sir, for taking time out and sharing your insights and years of knowledge. And I hope the viewers will find it interesting and will learn from it. Thank you so much, sir.
Thank you. Thank you for having me here. All the best. Bye.